The COVID-19 pandemic has affected all small businesses in the U.S. Virgin Islands, but there is help to move your business forward. The Virgin Islands Small Business Development Center is available to assist entrepreneurs and small businesses. The VISBDC is the territory's #1 resource for small businesses and is sustained by the University of the Virgin Islands and the U.S. Small Business Administration. The VISBDC is nationally accredited and provides one-on-one advising, business education training, and technical assistance at no cost. Attend workshops by experts from both the public and private sectors. From idea generation to exit strategies, the staff at the VISBDC are ready to assist you. So don't wait. Call, email, or visit them on the web at www.visbdc.org and Facebook, or simply download their mobile app on the Apple or Google Play Store. Just search VISBDC. Discover how they can help your business grow and succeed.
Good morning, everyone, and welcome to the U.S. Patent and Trademarks Office USVI webinar series. The U.S. Patent and Trademark Office is here to teach, clarify, and connect you to the resources available for the USVI small business community. I'm going to go ahead and introduce today's presenter. Brian Ye is an attorney advisor on the copyright team in the USPTO's Office of Policy and International Affairs. His international portfolio includes South America and Southeast Asia. He follows developments in local copyright regimes and serves as a resource for interagency teams working on projects affecting these regions. He is also a part of the U.S. delegation for meetings of the Standing Committee on Copyright and Related Rights as the World Intellectual Property Organization, and also the World Intellectual Property Organization. In addition, he contributes to the USPTO's copyright analysis in domestic litigation, legislation, and other policy initiatives. He received a BA in government from Cornell University and his JD from the University of Texas at Austin Law School. Just a friendly reminder to put your questions in the chat, and they will be addressed either directly in the chat or later during the question and answer segment. A copy of this presentation will be emailed directly after the presentation, in addition to a survey that lets us know how we're doing. We encourage you to take the time out to fill out this survey so we can continue to provide these types of training at low or no cost to you. So without further ado, Attorney Ye, the floor is yours.
Okay, thank you so much for the very kind introduction, Sharika, and thanks to you and the Virgin Islands SBDC for inviting me to speak here today on this important topic. And good morning, everyone. Welcome to today's webinar on copyright basics and considerations for entrepreneurs. A brief overview and introduction. My office in the USPTO is responsible for advising the White House and other federal government agencies on intellectual property law and policy issues, both domestically and internationally. We also provide technical assistance and training on IP-related matters to U.S. and foreign government officials. Now, today's program is an example of another form of PTO's training and outreach efforts designed to give small and medium-sized business owners and entrepreneurs such as yourselves an understanding of how to protect your intellectual property, which in this case means your copyrighted assets. Now, we'll cover the basics of copyright today, what copyright is, what it protects, and how it is secured. I have a lot of material to cover, and I'd also like to leave some time to take your questions, so I apologize if I may move fairly quickly through the slides. Also, I plan to pause at about every 15 minutes during my presentation to check if any of you have submitted any questions in the chat box, which I can answer. So please feel free to ask me questions to clarify what I may have said or to ask me any follow-up questions. If you ask me a question about something that I plan to cover later in this hour, I'll defer my response until then. Now, the information I'll provide this morning may be helpful to you in running your business, including in the following ways. Number one, identifying your work products that could be eligible for copyright protection. Number two, possibly licensing those copyright assets and generating royalty revenue from them. Number three, taking steps to safeguard your business from copyright infringement liability and other violations of your IP rights. And finally, number four, understanding how to possibly reduce your risks of becoming the target of a copyright infringement lawsuit if you use copyright materials that is made by other companies or individuals. Now, before going any further, I want to issue a standard lawyer disclaimer that I cannot provide specific legal advice about any particular copyright problem that you may be encountering. And for that, you should consult a copyright lawyer who is licensed to practice within your jurisdiction. If you need help finding that person, you can contact the Virgin Islands Bar Association, which has an attorney referral service on its website. So let me begin today with some fundamental points about copyright and its origins. Article 1, Section 8, Clause 8 of our U.S. Constitution gives authority to U.S. Congress to enact copyright and patent laws that promote and protect copyright, that protect and promote creativity and innovation by ensuring that authors and inventors enjoy certain exclusive rights to control public access to their writings and inventions for a certain amount of time. Now, the purpose of U.S. copyright law is expressly laid out in the constitutional provision that is displayed here on this slide. By establishing a copyright system, Congress has provided economic incentives for individuals and companies to create new artistic and literary materials, as well as to disseminate existing and new expressive works in order to stimulate creativity and promote the progress of learning and knowledge for the benefit of society and the enrichment of our culture. So what exactly is a copyright? Well, a copyright is a type of intellectual property, meaning it is a product and creation of the human mind, just like other types of IP that you may be familiar with, such as patents, trademarks, and trade secrets. Now, a patent protects inventions or discoveries, and a trademark protects words, phrases, symbols, or designs that identify the source of the goods and services of one party and distinguishes them from another. Trade secret law protects a company's confidential, commercially valuable information. By comparison, a copyright protects a broad range of creative expression, which is referred to in copyright jargon as original works of authorship, and includes literary, dramatic, musical, and artistic works. And you will hear me use the word works many times throughout this presentation. In the copyright world, a work just refers to an original piece of creative expression that meets the legal requirements for federal copyright protection. A copyright can apply to an extremely broad range of subject matter, and protection is potentially available for many types of artistic, literary, music, and audiovisual content that we all enjoy on a daily basis, including books, movies, TV shows, photography, paintings, video games, and music. To be successful in today's global economy, all businesses, including small-sized ones, should take steps to identify and safeguard their corporate intangible assets that are protectable as intellectual property like copyright. Now, this slide here lists just a few types of potentially copyrightable products that your business may be creating and using in its operation, such as advertising materials, internal corporate documents, photographs, and press releases. Other business assets that may be protected by copyright include databases and computer programs. And in addition, any content that is displayed on your company's website could be protected by copyright, such as any written material, artwork, video, and pictures that the business has itself created and published on its website. Now, I'll point out that in addition to the first 5 bullet points, first 5 items that's displayed on this slide, the last 2 things, which are logos and product design or packaging, are actually very rarely eligible for copyright protection, as they are likely functional in nature and do not satisfy the requirements for copyright protection. They are also unlikely to satisfy the threshold of creativity that is necessary for protection under copyright law, which is a requirement that I'll be discussing shortly. Instead, you should rely primarily on trademark law to protect your business's logos, names, and design and packaging of your products. But I will say that if your company's logo is an original work of art that you have the rights to, such as a drawing, photograph, or painting, you could try to claim copyright protection in it, especially if it is particularly intricate or creative in appearance. So for example, The drawing of a brand's cartoon character like a Mr. Peanut or the Pillsbury Doughboy could potentially be copyrightable. Similarly, the design of a product package, while rarely sufficiently creative for copyright protection, it might be eligible if it is features more than just a common geometric shape or more than just a very basic color pattern. Now, a final reason you should care about copyrights is that ignoring copyright law could be detrimental to the financial success of your business, particularly if your business is using any copyright content that you have not obtained a license to use, or that you cannot assert any legal rights or affirmative defenses to use. Unintentional or even willfully disregarding the copyright rights of others could expose your company to legal liability and the financial costs associated with being a defendant in a copyright infringement litigation. So how do you get copyright protection for your creative products? Well, there are two basic requirements as described in the Copyright Act and explained in several decisions that have been issued by the US Supreme Court over the years. Number one, the material must be original and creative. And number two, it must be fixed in a tangible form. Now, the first requirement of originality is actually fairly easy to satisfy. First, in this context, originality means that the author must have independently created the work and not just copied it from another party. There is no requirement that the work be novel or unique, as it is in patent law, or even that it must have some sort of artistic or aesthetic merit. In addition, originality requires that the work exhibit a modicum level of creativity. Even a slight amount of creativity will usually be enough. The second fundamental requirement for copyright protection is called fixation. And this refers to when a work appears or exists in some sort of tangible medium of expression. The form, manner, and medium of fixation are virtually unlimited. Creative expression may be captured in words, numbers, notes, sounds, pictures, or any other graphic or symbolic media, including paper, computer hard drives, a compact disc, vinyl record, a piece of canvas, clay, or stone. Now, the Copyright Act requires that the creative expression be fixed for a period of time that is more than a transitory duration. And that means that any work that is fleetingly displayed for the public or an unscripted, spontaneously given public speech would not be eligible for copyright protection. Now, as I have just explained, copyright protection is not available for any material that is not fixed in a tangible medium, or anything that lacks the sufficient creativity or originality that is necessary. And I already mentioned that most corporate logos and package designs are not usually protectable by copyright. Now, there are other things not eligible for copyright. The federal courts have determined that copyright law generally does not protect short phrases, mottos, or slogans, particularly those used to convey an idea that can only be expressed in a limited number of ways. Similarly, the names or titles of people, businesses, and products are uncopyrightable, though, as I mentioned earlier, these things could possibly be protected by federal and state trademark laws. Finally, the U.S. Copyright Act expressly denies copyright protection to any work of the U.S. federal government, which the Act defines as a work prepared by an officer or an employee of the U.S. government that is part of that person's official duties and job responsibilities. Thus, for example, a federal government agency or federal official and its employees may not claim copyright to a government record or government authored document, including statutes, regulations, or federal court opinions. Any material that is ineligible for copyright protection, or a work that no longer enjoys copyright protection because of the expiration of the term of copyright protection, are considered to be part of what's called the public domain. Works in the public domain are essentially owned by everyone, and thus anyone may freely use them without needing to get prior permission of the original creator of the work. Works can also be intentionally placed into the public domain by the creators in a process that is referred to as dedication. Now, the U.S. Copyright Act also expressly excludes from protection any idea, principle, procedure, process, system, or method of operation. However, copyright is potentially available to protect the way in which those things may be expressed or communicated. That is, copyright would apply to the fixation in a tangible medium of any description, explanation, or illustration of a particular idea, concept, operation, method, or discovery. This is an important and fundamental distinction in copyright law that is between protected expressions and unprotected ideas, and it is commonly referred to as the idea expression dichotomy. So, the idea expression dichotomy helps to strike a balance between the protection of an author's particular creative expression and the right of the public to freely communicate the facts and engage in free speech that is guaranteed by the First Amendment to the US Constitution. The idea expression dichotomy helps to prevent an author from monopolizing or excluding certain ideas from being used by other authors and artists, which would ultimately stifle free expression and free speech. So this expression idea dichotomy principle encourages people to figure out new and creative ways of expressing different ideas and concepts, while at the same time ensuring that copyright owners' rights to their particular works are protected. Legal protection of creative works derives from copyright law's grant of certain exclusive rights to the creator or owner of those rights. These rights are important for authors, artists, and content producing companies that want to receive compensation for creating and disseminating their works to the public. These rights also allow copyright holders to determine whether and under what circumstances their protected works may or may not be used by third parties. Now, the Copyright Act grants the copyright holder 6 exclusive rights, including the right to make copies of their creative work in any tangible medium, the right to distribute the work to the public, the right to prepare what's called derivative work, and the right to perform publicly or publicly display their work. Now, the right to make copies of a work is generally considered to be the most fundamental right in copyright's bundle of exclusive rights. Now, today, the reproduction right has taken on an increased importance due to digital technology and the internet, because copies of works are made in the process of any transmissions between computers, including any uploading, downloading of works to and from the internet. An exclusive right to prepare a derivative work describes or involves recasting, transforming, or adapting one or more pre-existing work into a new work, such as when a novel or a book is adapted into a movie, when a drawing is made into a sculpture, and when a poster is based on a famous painting. Examples of derivative works can also include translations of a textbook, musical arrangements, and abridgments. Now, the exclusive right to distribution of works gives the copyright owner the right to control the initial public distribution of copies of a work by sale or other transfer of ownership, or by renting, leasing, or lending the work. The right of publicly displaying a work refers to a copyright owner showing the work directly to the public who can view it in person inside a museum or theater, or a copyright owner transmitting the work to the public for viewing on a television or computer screen. Now, the right to perform a work refers to dancing, acting, playing, or rendering a work in public, and applies to a wide range of activities such as live concert performances, television and radio broadcasts, and playing recorded background music inside a bar, restaurant, or clothing store. And note that the rights of performance and display are limited to only those acts that happen publicly. The Copyright Act does define the word public to mean a place that is open to the public, or any place where a substantial number of people are gathered that are outside the normal circle of a family and its social acquaintances. Each of these 6 exclusive rights that is listed on this slide can be separately licensed by the copyright holder to third parties. So, for example, a third party who wants to reproduce the copyright work as well as publicly perform that work must negotiate and obtain separate licenses from the copyright owner in order to engage in those 2 different activities. So let me actually pause briefly and see if there are any questions. And I do see there are some in the chat, and let me take a quick look and I will try to answer them. So I have a question that says, for slogans that are part of a logo, that are part of the brand name, for example, can that be copyrighted? So let me answer that. Generally, no. Actually, I wouldn't say generally. I would say no, because as I said before, brand names, slogans, these are all things that really fall under trademark law protection, because they are things that identify a company and distinguish that company from its competitors, and identifies in the minds of the public the source of the company that's providing a service or a good. So those things, brand names, slogans, short phrases, so forth, would fall under trademark law and are not covered by a copyright. Now, the second question you have is there a website that contains a collection of works that are now available in the public domain? This is an excellent question, and unfortunately, the answer is no. Well, I will say that there could be, and I actually am not aware, but there could be some organizations that operate websites that attempt to provide some sort of database, searchable database, or other kind of listing that shows what kind of things are in the public domain or will fall into the public domain at a certain date. But those are not government operated websites. The US Copyright Office that administers the copyright system, and I will be talking about them in a moment, they also do not maintain any kind of way to check if something is in the public domain. So unfortunately, there isn't like a definitive authoritative list. And you need to kind of do some background research into what exactly you're trying to use, and investigate whether or not the copyright term is expired, or if there are any copyright ownership interests or anyone asserting copyright to that particular item. I see another question that's been submitted about trademark. Wait, it says the question is for trademark of a business name, what's the step for you to do as a future business owner? I am not a trademark attorney. I am familiar with some things with trademarks. I will say, generally, I believe you can file an application for trademark registration, certainly with my agency, the U.S. Patent and Trademark Office, so that you can secure the rights to use that particular business name in the course of offering your products to the public or your services. There are, I believe, other ways you can obtain rights to trademark, which do not involve formally filing a registration with the USPTO. Filing a registration for trademark protection with the USPTO gives you the right to use that brand name, that corporate business name, across the United States. If you do not file it federally, I believe by using the term and actively using it, you may obtain certain rights under state law, under Virgin Island common law. I unfortunately am not entirely familiar with that process, but I believe the Virgin Islands SBDC may have other information about that, or they may have additional training modules dealing with trademark law, in which certainly the person that's presenting that topic could answer that more directly. Thank you for these questions, and I encourage you to keep them coming as I continue talking through my presentation. Okay, so let's move on, and let me turn to the topic of copyright registration. Although before I do that, I should mention that there is actually an important international dimension that you should be aware of to copyright law. First, there is no such thing as an international copyright that automatically protects your creative works throughout the world. The US Copyright Act generally only applies within the territory of the United States. Protection against unauthorized use of your copyrighted works within another country depends on the national laws of that country. So if, for example, if you distribute your creative works in a foreign country and you have any problems with people or companies that use your creations without your permission or without paying for it, you would need to seek legal recourse under the copyright law or the legal regimes of that particular foreign jurisdiction. But I will say that several elements of US copyright law owe their existence to international copyright treaties and international conventions that the United States has joined over the years. These treaties establish obligations regarding IP rights and protection that member countries must comply with and agree to implement within their domestic laws. These treaties and conventions establish both minimum standards for protecting copyrighted works under domestic laws and for extending the same legal protections to the works of other member countries' authors under the principle that is referred to as national treatment. Now, national treatment requires a country to give nationals of other countries that are members of the same international agreement no less favorable treatment than it provides to its own citizens. The United States has copyright relations with most countries throughout the world, and as a result of these international copyright treaties, we do honor each other's citizens' copyrights. However, the United States does not have copyright relationships with every country. So let me briefly describe one way that international treaty obligations have impacted the operation of the US copyright system. Under the most important copyright treaty called the Berne Convention, member countries have agreed to ensure that under their laws, their domestic national laws, the enjoyment and exercise of copyright shall not be subject to any formality or formal legal requirements. So, for example, a country may not require as a precondition to obtain copyright protection that a work has to be registered with a government entity, or that a copyright holder must attach a particular notice of copyright protection onto the work. These types of requirements would be considered impermissible formalities under the Berne Convention. However, the Berne Convention does give member countries the option of requiring fixation as a condition of copyright protection. The United States has chosen to include that requirement in our domestic law. That is why under the US Copyright Act, a work must first be fixed in a tangible meaning of expression before copyright protection arises. And while the United States does not require copyright registration of a work, because such a mandate would be inconsistent with the Berne Convention, the Copyright Act instead offers certain incentives and legal benefits that will encourage copyright owners to voluntarily choose to register their works with the US Copyright Office. And I should also now briefly explain that the US Copyright Office is actually a separate federal agency from the USPTO that handles the regular administration of the copyright system. By contrast, the USPTO, which is my agency, does not administer any part of the US copyright registration system. Instead, the USPTO administers the process of registering and awarding patents and trademarks. So what are the benefits of copyright registration? First, a registration establishes a public record of the copyright that's being claimed in a work and puts the public on notice about the ownership status of the copyright in question. Obtaining a registration is also generally required before a copyright owner can file a lawsuit in federal court over violations of their copyright in a US work, or the person must have received a Copyright Office rejection letter of their registration application. Now, timely registration of a copyright work is also a prerequisite for eligibility to receive attorney's fees and a statutory monetary damages, which are two important legal remedies that a court can award a copyright owner that wins its case against a defendant. And I will describe those legal remedies a little later in my presentation. Registration also makes it easier for a copyright holder to prove the validity of the copyright in federal court, which is an essential element of a successful copyright infringement claim. Registered copyrights can also be recorded with the U.S. Customs and Border Protection to help CBP personnel at over 300 ports of entry figure out whether imports of goods into the United States infringes a U.S. copyright. Upon making that determination, the CBP can detain and seize foreign-made pirated goods before they have entered into the U.S. market. And finally, having an official registration of a copyright claim may make it easier for an individual or business to license a work and collect royalties for third parties who are interested in using the creative materials and want to secure permission to do so. Now, to register a claim to copyright, you must fill out and submit an application either online at www.copyright.gov, or you can use paper forms that you then fill out and mail to the U.S. Copyright Office for processing. I will pause here to briefly mention a particular persistent myth about copyright protection that is called or is referred to as a poor man's copyright. And my understanding of this concept is that it describes how an author can try to establish copyright protection by simply mailing a copy of a copyrighted work to him or herself using the US Postal Service, and then using the postmark as proof of the date on which the work was created or was possessed by the author. However, the US Copyright Office has fully debunked this myth on its website and points out that this form of this process is not a substitute for formal and official registration, and that poor man's copyright process does not give any access to the legal benefits that flow from official registration. Now, in addition to filing an application, a copyright owner must pay a non-refundable filing fee and deposit copies of the works to be registered with the US Copyright Office, either electronically deposited, submitted, or sent through the mail. Registration fees range from $45 to $65 for e-filing an application and $125 for paper filing. Electronic filing does offer several advantages, including it speeds up the processing time, it provides an earlier effective date of registration, and it allows online status tracking for the application. Copyright registration is effective on the day that the Copyright Office receives all the required elements of a proper application for registration, including the application itself, the filing fee, and the mandatory deposit of copies of the work, no matter how long it takes for the Copyright Office to actually process and approve the registration. Now, unlike applying to the USPTO for a patent or trademark registration, registering a copyright with the US Copyright Office is not a very lengthy process and does not involve a very substantive, onerous examination of the application. The processing time for applications can vary a lot depending on the circumstances of each individual case and the number of applications that the office may be reviewing at that same time. But currently, the office's average turnaround time is between 1 to 3 months for applications that are filed online, and an average of 4 to 8 months for mailed-in forms. Now, upon approval of an application, the Copyright Office will issue the applicant a certificate of registration. Now, there are examiners within the Copyright Office who will look at an application's description of the copyright being claimed in the work, and they will evaluate whether the work meets the requirements and standards for copyrightability. Now, the Copyright Office refuses registration for only a very small percentage of applications. If your application is refused registration, you can appeal that refusal, first by making a request for office reconsideration. Now, if that office request for reconsideration is not successful, you can appeal that decision to the Copyright Office's review board. This step is referred to as a second request for reconsideration. The review board consists of the head of the Copyright Office, who's known as the registrar, the general counsel of the Copyright Office, and a third member who is designated by the registrar. A decision by the Copyright Review Board in response to this second request for reconsideration is considered to be a final agency action, meaning that after that happens, the unsuccessful applicant can appeal the final decision of the Copyright Office to the federal courts for judicial review of this agency action. So you have probably seen a copyright notice before, either printed inside a book or displayed at the end of a movie. A copyright owner places this kind of a notice on copies of a work to let the public know that it is protected by copyright. This notice also reveals the year of first publication of the work and the name of the copyright owner. This slide shows you an example of a copyright notice. Prior to March 1st, 1989, the US copyright law required the use of a copyright notice in order for a work to receive copyright protection. But then in 1989, Congress amended the Copyright Act so that it is no longer requires anyone to place a notice in order to secure copyright protection. Thus, for works first published on or after March 1st, 1989, the use of a copyright notice is entirely optional on the part of the copyright owner. And the reason why it happened in 1989, by the way, is because that's the year the United States joined and signed on to the Berne Convention, the International Copyright Treaty I mentioned earlier, that does not allow for formalities, requirements such as a notice being placed. But even though the use of a copyright notice is now entirely optional, it still has a several useful purposes, including that it helps identify the copyright owner and the date of publication. and it makes the public aware that the work is protected by copyright. The identifying information that's shown in a copyright notice could also prove helpful to any third party that wants to know who to contact in order to obtain permission to use the work. Another possible benefit of using a copyright notice is that it allows the copyright holder to overcome the so-called innocent infringer defense, which is not actually a defense to liability, but instead can help reduce the amount of money damages that a defendant may have to pay in a copyright infringement lawsuit. If the defendant can prove that he was not aware and had no reason to believe that his actions constituted an infringement of copyright, a federal court could substantially reduce the calculated award of statutory damages. However, the Copyright Act prevents a defendant from asserting the innocent infringer defense where the copyright work in question displays or contains a copyright notice. Now, the exclusive rights granted to the copyright holder do not last forever. In general, for works created after January 1st, 1978, copyright protection lasts for the duration of the author's life plus 70 additional years after his or her death. For copyrights that are held by a business, a copyright lasts 95 years from publication or 120 years after creation, whichever comes first. For works created before 1978, the copyright term is actually far more difficult to calculate and depends on several factors that include whether it was published or unpublished and whether the registration was renewed with the Copyright Office. Those considerations are no longer valid for works that are created after 1978. Now, in any case, at the expiration of the copyright term, the copyright work, as I said before, will become part of the public domain. Works in the public domain, as I mentioned earlier, are free and available for anyone to use without fear of being sued for copyright infringement. Now, the ownership of copyright and the right to exercise or license the exclusive rights granted under copyright are important for authors and companies that want to receive compensation for producing and disseminating their creative works. Under the Copyright Act, there are primarily three categories of copyright ownership: individual authors, joint authors, and works made for hire. Now, the first, the basic rule is that copyright initially belongs to the individual who comes up with the idea for the work and first fixes that idea in a tangible medium of expression. The Copyright Act also recognizes joint authorship of a work, which refers to a work that is being prepared by two or more parties, authors, with the intention that their contributions be merged into inseparable or interdependent parts of a single work. Joint authors are co-owners of their work, meaning that each person owns an undivided share of the copyrighted work. Either co-owner may exercise any of the exclusive rights of copyright, including granting non-exclusive licenses to other parties without consulting with the other co-authors. However, each co-author has a duty to account to the other co-authors for any profits that are obtained from the exploitation of the work. And neither co-author may grant an exclusive license without the consent of the other or do anything that may destroy the value of their joint work. Under certain circumstances, the copyright in a work is not initially granted to the original creator or author of the work. In the cases of a work made for hire, the employer of the creator of the work is considered to be the author and thus the owner of the copyright for purposes of the Copyright Act. Now, there are two types of works made for hire: those prepared by an employee within the scope of his or her employment, and those works that are prepared by an independent contractor by special order or commission. So as it relates to your business and your employees who may be drawing or photographing or writing things for your business, they would not be considered the owner of those works that they've created if those are things that they've done as part of their job duties for the business. The business itself would be considered the owner and the creator of the work in question under this work made for hire doctrine. Let me pause here and I will answer some more questions. I do see a few that have popped up in the chat. Or actually, I just think, or maybe it's just a comment. And yes, thank you very much. I wasn't sure. So the comment that was made was that someone had heard about this poor man's copyright concept or this idea. And actually, I was surprised that it's even still out there. But I think I was asking around to any of my friends who were did not really know copyright, and they also thought all you needed to do was mail whatever you wrote or drew to yourself in the mail, and the postmark counts as copyright registration or whatever. And yeah, unfortunately, I don't know where that myth was started and where that was perpetuated, but that is a myth and is not the proper way of getting copyright protection. So thank you. Okay, let me move on. So let's see. In order for a third party to use a copyright work in a manner that falls within the scope of a copyright holder's exclusive rights, the third party usually must obtain prior permission to do so. Such permission is often expressed in the form of what's called a license agreement that will specify the terms and conditions of use and may involve the payment of money that is often called a royalty fee or royalties. Now, if a third party does not obtain permission to use a copyrighted work, this could be considered a violation of the copyright holder's exclusive rights, and the third party could be subject to legal action for copyright infringement. In general, federal courts use a two-step approach to determine whether an infringement has occurred. First, the copyright owner, as the plaintiff in the case, will introduce a certificate of registration that he's gotten from the Copyright Office, because that registration certificate constitutes prima facie evidence of the validity and ownership of the copyright. Now, the alleged infringer, as the defendant, may then introduce evidence to rebut that presumption of validity or ownership of copyright. So, for example, the defendant could try to argue that the work is actually in the public domain or was not original to the author and is thus uncopyrightable. Second, the plaintiff must show that the defendant had copied his protected expression or otherwise committed certain acts that violate one of the copyright owner's exclusive rights. Now, in response, the defendant could raise certain affirmative defenses, such as the defense of fair use, which I will talk about in a few moments. Under the Copyright Act, a person who does something without authorization that implicates the exclusive rights of a copyright owner is directly liable for the infringement. Under certain circumstances, however, a person may be considered to be indirectly liable for the infringing activities of others. US law recognizes two types of indirect copyright infringement liability: contributory and vicarious. Under the doctrine of contributory liability, a person may be liable for the infringing conduct of another when he has knowledge of the infringing activity and induces, causes, or materially contributes to the infringing conduct. For example, the owner of a store could be held liable for the infringing activities of his customer if the owner sold them blank recording media while letting them borrow copies of copyrighted sound recordings. Under the doctrine of vicarious liability, a person may be found liable for the direct infringing conduct of another party when that individual has the right or ability to control the conduct of the infringing party, and when the defendant enjoys a direct financial interest in the infringing activities continuing. So, for example, the operator of a flea market could be held vicariously liable for allowing vendors to sell infringing merchandise on the premises of that particular farmer's market, flea market, what have you. So I've so far focused solely on the exclusive legal rights that the Copyright Act provides to copyright holders. But the framers of the US Constitution believe that the copyright system should be balanced between the copyright owner's exclusive rights and the ability of the public to make reasonable uses of creative works. The problem is that each of us has a different idea of where that balance should lie. And because of that, there's actually a very long-running and ongoing debate in the community, among stakeholders, among parties, and in the courts over where that balance should be. Now, to ensure that copyright does not unduly restrict certain uses of creative material or unnecessarily restrict the public interest in accessing certain facts and knowledge and information, the Copyright Act does contain several statutory limitations and exceptions to the exclusive rights of copyright holders. These limitations on the exclusive rights help to fulfill copyright's basic purpose by allowing authors to build upon the works of creators who came before them. If a particular use of a work comes within the scope of a limitation or exception to copyright, then that activity, that use, even if lacking in express authorization or permission by the copyright holder, does not constitute infringement. There are several statutory limitations and exceptions to copyright that allow the following activities to occur, to be conducted: library and archival copying, educational and nonprofit broadcasting, nonprofit live performances and displays, reproductions for the blind and disabled, and making copies of computer programs for archival or maintenance purposes. One of the more important limitations to the copyright exclusive rights is called the first sale doctrine. And this limits the copyright owner's exclusive right to control distribution of the material objects in which a work is expressed. The first sale doctrine is the reason why a bookstore, someone who buys a book from a bookstore, can turn around and sell that copy of the book to a used bookstore or give it away or whatever, can do whatever they want with it after they have purchased it, and that they do not need to get prior permission of the publisher of the book, the author of the book, to engage in this kind of downstream distribution activity. However, I will say that the first sale doctrine does not limit all of a copyright owner's rights. So just because I bought a book at a bookstore and I can turn around and give away that copy or sell it to somebody else, does not mean because I own that book, I can copy it and sell it, sell those copies. That would be a violation of the reproduction right of a copyright owner, and the first sale doctrine limitation does not apply to reproduction right. Now, let me talk a little bit about fair use, because that might be something you've heard about. The doctrine of fair use in copyright law is probably the most well-known and arguably the most important limitation on the exclusive rights of a copyright holder. However, it is also one of the most fiercely contested and possibly misunderstood issues in copyright litigation. Now, fair use recognizes the right of the public to make reasonable use of copyright material under certain circumstances without the copyright holder's consent. For example, a teacher in a classroom may be able to use short excerpts of copyright works in preparing a lecture without getting prior permission to do it. The Copyright Act provides that fair use is available for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. But whether any particular action or activity is considered to be a fair use, even if it falls into one of these kind of descriptions, it is still up to a federal court to decide definitively on a case-by-case, fact-specific basis whether that activity constitutes fair use. To provide some guidance to federal judges that would be tasked with, which would be required to make these difficult fair use determinations. In 1976, Congress incorporated into the US copyright law a balancing test of statutory factors that I will describe in greater detail during the next slide. The first statutory fair use factor requires the court to consider the purpose and character of the defendant's use of the copyright material, including whether such use is of a commercial nature or is for a nonprofit educational purpose. Considering the purpose and character of the use, courts also place great emphasis on whether the use of the original work is seen as being transformative. In general, courts have found that the use of a copyright work is transformative when the use has added something new to the work, thereby altering the original work by giving it a different purpose, expression, meaning, or message to the public. Such uses are more likely to be viewed as fair. And the more transformative the use, the more tolerant a court may be of the commercial nature of the use. Under the second factor, courts will look at the nature of the underlying copyrighted work. Courts are less likely to find fair use in the case of creative and imaginative works and for published works. On the other hand, courts are more likely to find fair use when it involves predominantly factual or functional works. Now, under the third factor, courts will evaluate how much the alleged infringer borrowed or took or used from the original underlying source material, as well as the significance of the material that was copied or borrowed. Generally, the greater the amount that was taken, the less likely it is that a court will find fair use. However, there's no bright line rules on how much a copyright work may be copied. Any court must analyze the extent of the borrowing or the use, both quantitatively and qualitatively. Under the fourth and final factor of fair use, courts will look at the effect of the use upon the potential market for or value of the copyright work. They might also evaluate the extent of the market harm that results and is that is done due to the actions of the infringer. Now, the Copyright Act does require a federal court to consider all four of these factors and weigh them together in a balancing test before deciding whether a particular use of a copyrighted material is considered to be a fair use. By the way, I should also stop here briefly to say that I have emphasized several times that it's a federal court that will make these determinations. I've also mentioned federal copyright law. I don't mean to say that, I don't mean to give you impression that there is state copyright law, because there isn't. Copyright law is exclusively a federal legal provision, and only federal courts can handle, generally can handle copyright related disputes. Now, the Copyright Act does authorize courts to award several civil remedies to the copyright holder that is harmed by infringement, including the possibility of obtaining injunctive relief, actual damages, statutory damages, and costs and attorney fees. Briefly, these remedies, I will briefly describe them. Actual damages are the actual damages that are suffered as a direct result of the infringement, and any profits that may have been lost that they can prove is attributable to the infringement. But as an alternative to receiving actual damages and profits, because it could be hard for a copyright holder to try to prove that under some circumstances, the Copyright Act does allow the copyright owner to choose to recover what's called statutory damages. A federal judge has wide discretion in imposing statutory damages, which range from $750 to $30,000 for each infringed work. And that amount of statutory damages can actually go as high as $150,000 if the infringement was conducted willfully. There's also various types of injunctive relief that a court can issue that will prohibit or compel certain conduct from the defendant. These are preliminary and permanent injunctions designed to prevent or restrain ongoing copyright infringement, or to seize and impound any infringing copies that were made and the materials and tools that were used to make the illegal copies. And finally, the court is allowed in its discretion to award reasonable costs and attorney fees to the prevailing party in an infringement lawsuit. Outside of the federal court system, there's actually a very new mechanism for copyright holders to resolve their legal disputes with users of their work. And this mechanism is one that promises to be more efficient and user-friendly compared to the federal judiciary system. The US Congress has for many years been concerned about the high costs of copyright litigation that may discourage small businesses and independent creators with limited financial means from enforcing their copyright rights. Some experts have estimated that it costs approximately $400,000 to file a federal copyright lawsuit through trial in order to get for a legal claim that's valued at less than $1 million. Congress concluded that a special forum was needed to provide a less costly means for resolving infringement disputes. And in December 2020, Congress enacted into law the Copyright Alternative in Small Claims Enforcement Act, or the CASE Act. This law required the U.S. Copyright Office to establish and administer a voluntary, streamlined, and faster administrative adjudication process that will be handled by a new Copyright Claims Board that's located within the U.S. Copyright Office. And this Copyright Claims Board will be empowered to consider copyright infringement matters for claims that do not exceed $30,000. The CCB consists of 3 experts in copyright law and alternative dispute resolution. No one will be able to bring a proceeding in the CCB seeking more than $30,000 total. If a party is seeking statutory damages, the CCB will not consider whether infringement is willful. This means that parties will be assured that they cannot face as high of damages as those that are available in federal court, which I mentioned earlier can be up to $150,000 per infringed work. This also means that a defendant may prefer to have an infringement case being brought against them within the CCB because there is less financial pressure on them to settle a case compared to the possibility of a high amount of damages that is available in federal court proceedings. There is also limited ways of appealing a CCB decision. If a party disagrees with the outcome of a CCB case, they can seek review both in the Copyright Office and in federal court. The CCB officially opened its virtual doors to hear copyright disputes involving claims of up to $30,000 on June 16, 2023, so less than a year ago. A party needs to have registered his or her work with the Copyright Office or have at least submitted a registration application in order to start filing a claim with the CCB. CCB proceedings are designed for people to understand and navigate easily. And it also makes it easier for them to represent themselves instead of hiring legal representation, hiring attorneys. Now, participants in a CCB proceeding are allowed to hire an attorney, but are not required to do so. And there are actually options for parties to get free legal assistance from a volunteer lawyer association or a law school clinic. So you get help from a law school student. The process of discovery in a CCB proceeding is limited and mostly paper-based, and parties will rely primarily on written material. CCB proceedings generally do not include formal motions unless required by requested by the parties or the CCB. As a result, CCB proceedings require far fewer resources and money and time compared to federal court lawsuits. In addition, when the total damages sought in a claim are less than $5,000, there is even more streamlined procedure that the CCB offers that handles those smaller claim amounts. These claims of $5,000 or less are decided by a single copyright claims officer instead of the full 3-panel CCB. CCB publishes its decision online. These decisions are not precedential, meaning that the CCB won't have to follow them in later cases, and they have no impact on unrelated federal court proceedings. There are safeguards against attempts to abuse the CCB system. Parties bringing claims in bad faith may have to pay the other party's reasonable costs and attorney fees. And in certain situations, the CCB can also ban bad faith parties from filing any new matters for up to 1 year and may dismiss all of their pending claims. CCB can also limit the number of cases that any one party can file in a year. Now, copyright holder is not required to bring claims in the CCB and can decide to just use the federal court system instead to enforce copyright. However, a party must make a choice between using the CCB or federal court. That is, the party cannot file the same claim or counterclaim in both venues at the same time. A party that is formally served with notice of a copyright claim being brought against them in the CCB has 60 days to decide whether to participate or to opt out of the proceeding. But if a party opts out of the CCB system, the other party can still file a federal lawsuit, which, as I said earlier, would likely be more expensive and time-consuming. And finally, an important limitation of the CCB is that, in general, claims cannot be brought against a person or business who does not reside in the United States, although a foreign resident can bring a CCB claim. Also, claims cannot be brought against before the CCB by or against a federal or state government entity. The CCB's website contains a handbook that is a practice manual for the CCB and provides an in-depth explanation of the tribunal's conduct of proceedings and gives assistance to claimants and respondents throughout the process. There's also a very useful frequently asked questions webpage on its website, ccb.gov. And the links on this final slide that I have shown here may offer helpful information to you regarding many of the topics that I have discussed and touched on today. So with that, I've reached the end of my formal presentation, and I thank you for your attention. I do see, I believe, there's one more question from an attendee. It says, do t-shirt designs and phrases fall under trademark or copyright? Now, this is actually a very interesting and unfortunately a little bit of a complicated question. Generally, I would say that a design, if it's a particular intricate artistic design that is being reproduced on a t-shirt, that design you could attempt to get copyright registration for, because it is a artwork. It's something that you have created. as long as it's not just a design that is a simple geometric pattern, something that's very basic. Phrases, as I said earlier, just are generally not protected under copyright. It would have to be like an entire passage, like an entire paragraph or something like that. That potentially could be copyrightable, but if it's just a short phrase, not even a full sentence, it is more of a trademark law protection, if protectable at all under intellectual property laws. And yes, so I do not see any other questions. Sharika, I can turn it back over to you for any final remarks.
Alrighty, I don't see any further questions as well, but in the interim, the VI SPDC has so much more in store for the US VI small business community. You can visit our website at www.vispdc.org. Download the VI SPDC app in your mobile device from the appropriate app store. Like and follow us on Facebook, Instagram, Twitter, Google My Business, and subscribe to the VI SPDC YouTube channel for more uploads of our on-demand webinars. So we're still looking for questions in the chat, so go ahead. Here's one.
Oh,
Can
okay.
the
I guess,
artist claim the copyright if they make a design for a business?
yeah, again, I think it's the same issue. I think if the artist, oh, I see. Okay, so there's a couple ways I read this, but if the design is particularly intricate and unique and creative, and it looks like a piece of art, as opposed to something that's more of a corporate logo that's, just kind of basic, that particular design could be copyrightable. But the other question is who owns it? And if the business in question had commissioned the artist, actually the artist is someone that's not an employee, but the company says, I'm going to put out a request, somebody and pay somebody to create this for us. It would have to depend on the terms of the contract as to who is entitled to the copyright. But under the default rule, if it is something that the company is paying someone else to do for them, that would be considered a specially commissioned work, and that comes under the work for me for hire. And then in that case, the copyright should belong to the company that paid for the design, and not the artist that did the work for the company under compensation or under a contract. So it does kind of depend on the contract terms between the artist and the company.
I don't see any more questions, but I'll take this time to advertise a few events we have coming up. This Saturday, we have the Empower Hub pop-up shopping festival being held by the Women in Business VI and local chapter. That's going to be at the Emancipation Garden. It's going to be from 10 a.m. to 5 p.m. So come on out and support our women in business. On May 24th, we have the USVI Federal Contracted Opportunities Workshops. We encourage small business owners of the St. Thomas, St. John district to come out in person to the VI SPDC location here on the UVI campus by the 13D Innovation Center on the second floor. We want you to come prepared with your capability statement so you can see what contracted opportunities are available locally. On the 24th, we are back with this USPTO series, and we have resources for inventors, innovators, and entrepreneurs. That's another webinar that's going to be happening at 11 a.m. On the 25th, we have VI Apex with the 8A Business Development Program webinar that starts at 11 a.m. And then we close off the USPTO series with small business owners learn how to contract with the USPTO. So that's going to be on May 31st, and it's going to be starting at 11 a.m. So I don't see much questions in the chat. I am in New York. I wish I could come Saturday. Definitely pay attention to our social media events for those of you abroad that want to basically have a snapshot of the fun we had networking here locally. So without further ado, I think that's it. Brian, we want to thank you and your team for collaborating with us on this effort. And on behalf of the entire USVI and the VI SPDC network, we say thank you. And to everyone, thank you for attending and enjoy the rest of your afternoon.
Bye-bye. Thank you.